What is more relevant now, the fight for freedom or the fight against the seizure of assets, taking into account the measure you have carried out today? Mr. Wanta, from my point of view, both of them are relevant. Any measure that isn't considered to have a legal base against a person that enjoys all the rights and freedoms will be challenged in the court of law, and the court will establish if this measure was legal or not. But how did the seizure of goods, cars and property affect them personally? I think any violation of a fundamental right causing you harm will be affected at least by relative nullity due to the fact that a fundamental right guaranteed by the addendum to the first act from the European Convention on Human Rights is violated illegally, in this case the right of ownership of a private person. In the courtroom you were saying that they don't intend to sell the seized goods until the case is finalized. What would they like to do with the cars and the properties? The discussion is not about what would I or what wouldn't I do. I want to freely and timely enjoy the goods that are part of my property at the moment of any opportunity presenting itself. Not only that they don't want to sell the seized goods, but also some of them were purchased after the 11th of April 2022. So if they had any intention to alienate their patrimony in order not to be the subject of a civil dispute or an extended special forfeiture, they could have done it 100 times between April and December. So, I want to freely enjoy the goods that are part of my property, whenever I want to, whenever I consider it relevant, whether I want it or not. I don't have to stay with the goods with a measure imposed on them, just because. What? There are injured parties, there are civil parties, new civil parties might appear. Possible civil claims should be covered, compensated from these seized goods? Very good question. The only civil claims made until now are not even 0.1% from the seized goods value amount. On the other hand, according to the case of law, once a measurement has been carried out, there must be a relative assessment of at least one potential damage, or at least a possible sum obtained illegally, or, as we are dealing with a case that started in April, so publicly debated, until now no other injured persons have appeared or civil claims have been made. The situation is extremely disproportionate, as I have explained. One of the fundamental principles was not observed at the time when the seizing of goods procedure had been carried out, namely the principle of proportionality. As a matter of principle, they say that these goods were bought with money made outside of Romania and not from these alleged, so-called alleged organized crimes offenses. At the moment that I'm on trial for such a measure being carried out, I'm not in the position to prove the income. I'm in the position to prove that the measure is abusive compared to what I have discussed earlier. A fact for which, thank God, in the criminal process the evidence of income is done by the prosecution and not by the defense in this regard. That is why we're not discussing at this moment the source of income, from where the amounts were obtained, and so on. Thank you, sir. Thank you. I have to go. One last question. How did the brothers receive the rejection of the appeal, especially since they were counting on a release? And I say this take into account the fact that they have asked not to be brought to the courtroom for this procedure. They don't want to face the judges anymore. Are they disappointed? Or what was their reaction to the yesterday Courts of Appeal decision? The reaction of any man who would hope for a release and for a judicial success on the part of an appeal against the measure of preventative detention. They didn't receive the news well at all, but that doesn't stop them from fighting to find out the truth on the one hand, and on the other hand, they didn't show up today not because they don't want to face the judges, but because that was a procedure that did not require taking their statements, their presence, so in order to facilitate the process for us and for them, they decided not to attend again. Will you ask in the meantime to change the preventative measure of detention to another procedure? We haven't decided yet.